Oh, okay. That's
Oh, that's.
There is an add-on on this page 3 at the bottom. It says Lamarian Bean, but I don't have that file in this. Lamarian.
right here, Judge. Sorry. It was on the bottom of the stack.
Is Lamarian Bean?
Good.
He's in custody.
Yes, sir.
Do we? What do we need on this one?
This is a case in which he was on his way to court and actually went to, and his family members here will say that he actually complied with the court's order. He then came back up here, apparently didn't get checked in, so he was arrested. He's been in jail now for about 2
He
weeks.
didn't get checked in. What's that mean?
His case is now reset. I'm not sure, Judge. I'm just saying that he went to jail. He showed up for court on that day. I spoke with him on that day. He then later was arrested.
I still don't understand.
There's not a bond on him, Judge. I don't think the court has set a bond because you haven't had a bond here or anything of that nature.
On February 4th of 2025, there was an affidavit of surety to surrender the bondsman, Stan Stanley. The states the defendant has refused to report as required. He's failed to appear for his municipal court, does not have a stable address. This bond is at risk. Request a warrant so that surety may recover the defendant to custody prior to his court date.
This was something from
this was back in February, so I ordered a warrant to be issued and a hearing upon the defendant's arrest.
Judge, I believe Ms. Jordan probably knows more about this than anybody else. But Mr. B did appear in municipal court as ordered.
But somebody's got to. The court makes findings, and this reset ASAP. The bond to be set. Defendant is in jail with no bond. This was on 5/21. So I guess that's what this hearing is on.
I believe it is, Your Honor. And Ms. Green?
Yeah, bring him out, Tommy. Thank you.
Mr. Meany been in jail. I've talked to him at least twice.
Hold on. Let me finish reading this. Thing. All right. Let's see. Defendant in 24 CR 2413 is the state of Texas versus Lamarian Bean. Is that you?
So,
Yes, speak out so she can hear. You're here with Mr. Grove, your attorney, and the state's attorney. You are charged with the second-degree felony of aggravated assault with a deadly weapon. Okay, go ahead, David.
All right, Judge, somehow, and I imagine I was partially to blame for this, although I'm not real sure exactly what happened. Mr. Bean was sent to go to court on, I believe, on the 21st
Of what month?
Of May. And he did not go to court at the time. He actually had been told by someone at the court, and it wasn't me because I didn't know about the hearing. He also had a hearing at the Beaumont Municipal Court.
When?
And I believe that would have been on the same day. Well, I'm not sure. Wait, did you have a court date in the Beaumont Municipal Court? Do you remember when that was? You came to court here.
What day? What day?
We're talking about November the 13th or that, because that would have been last year. That's when this offense occurred. Or February the 13th? You actually went to court. Is that correct? All right. What happened over there? They said there was a warrant because you don't here again at Stevens Court.
wow, it's in the gun building to the
Man, that's not right. No, I got all the documents. A warrant was issued for him on February 4th. And there was his bondsman submitted an affidavit to surrender him because the defendant refused to report to the bondsman, has already failed to appear for his municipal court date, does not have stable address, and the bond is at risk, requests a warrant. So a warrant was issued and the court ordered a hearing upon his arrest. I don't know when AFRS, no bond forfeiture. And actually, the court ordered a $60,000 bond and a GPS device on 2/13. Defendant was taken to jail on 2/13. And seven 2/25, an announcement. And the court notes the defendant in jail. Then on March, I reset it for March 4th for an announcement on March 31. Just keeps getting reset somewhere. The last one is on 5/21. It was this court set it for, I'm sorry, on 5/12, I set it for 5/21 on a hearing on the bond issue. I don't know what happened, but on 5/21.
I believe, Judge,
Then we reset as soon as possible for bond to be set, and that's that's the third or fourth time I reset this with exclamation points, which means it's not being done, and there's a time factor here. So now he's here. I don't know what took so long.
Has he been under bond conditions
No.
at any point?
No,
because he's jail, Judge.
No, I know he's been in jail, but we keep resetting it to get him up here, and he's not showing up.
I'm gonna make the court aware that from the jail, he's been communicating with the complainant in the case quite a bit.
Judge, he's been in jail. He's been in Jefferson County Jail since the day he was first arrested in this court. He hadn't been anywhere else. Now, I don't know why he hadn't been getting up here or what the situation there is, but he hadn't been brought up here.
They were sitting every time.
I know. Well, hold on.
I think last week
That's fine, David, but you're his attorney. Somebody needs to make it known to me that there's a problem. I've got 5,000 defendants. I mean, we're trying to get everybody done, but
Yes, sir.
somebody's got to wave the flag, and because this doesn't happen normally.
last week, Judge, it was Mr. Grove had to leave early from court, and that's why we didn't get to reach this hearing.
Okay. All right. So time for bond. He's here.
Yes, sir.
Let's move forward.
Further, Judge, I've been provided with 4 telephone numbers by Mr. B, and I've called all 4 of those more than once. Hadn't been able to get anybody from his family talking about why he wasn't here. But I do have 4.
He's here.
Yes, sir. And he
Go
doesn't
ahead.
know why I had.
Go ahead. What do you want?
So, Judge, I think if we could ask the court to set a bond on him, I believe he did appear on the date he was supposed to appear, and he has been in custody for some period of time. And I'm sure that there's many things I should have done and I didn't do, obviously. So I apologize to the court.
Good.
But
Let's go. What do you want to do today?
I'd ask the court to reinstate his original bond
Why?
that he had in this case, because he has made all of his appearances as far as in fact, although I think technically he did not resign it. On the first time he was brought down here, which I believe may have been February the 13th. He had been arrested the night before and was very upset. And some of the bailiffs, some of the female bailiffs, spoke with him and calmed him down, but he did not appear before the court on that day. And I believe that he did appear, but he didn't. I believe that's from the original.
What was the original bond? I don't think that's sufficient.
And then the bondsman got off of, it was $30,000, the bondsman. That was made on the day after Christmas.
Yes, sir.
And then he, it says the defendant's refusing to report as agreed weekly, failed to appear at his municipal court date, does not have a stable address, the bond is at risk and requests a warrant. That was on February 4th. And that's what, what granted this affidavit of surety to surrender with an order having a hearing when he gets arrested. For some reason, my order was not followed back. Okay, I think I understand where we are here. Go ahead.
One other thing that, and I was bringing this up, but I believe since he's been incarcerated so long that I think he will show up. Mr. Eckhart indicated that the defendant had been contacting the complaining witness. I have no knowledge of that, although the complaining witness has called me and has spoken to me in this case, so I can believe something like that happened. But I'd ask the court just to consider reinstating his bond, and I apologize because obviously most of this was my fault because I did not ask for a bond earlier. I should have been able to get in touch with his family, but he could not.
Okay, who have you talked to?
Early on, Judge, I talked to Mr. Bain's girlfriend or wife,
who is
Miss Gassworth. And she was still living with him. They were living in Jasper the last time I spoke to her, but I've been unable to get in touch with her. I've also spoken to his mother on one occasion.
who is what's that person's name?
Shaw. Shaw. And Miss Shaw.
What was that, first name or last name?
So that
Miss Shaw.
And but I haven't been unable to get in touch with her. I spoke with Margie Matthews, who is the complainant, and at the time of the incident, he was actually staying with Mr. Bain and his wife, but when I spoke with her, she was staying at a different location, and I don't have that address. I just had a phone number that she calls. And then also they gave Miss Gassaway, he gave Miss Gassaway his phone when he was arrested, and I've tried to get in touch on that, and that has been disconnected. And I believe that was Miss Gassaway that had that.
Okay, well, so what is the point you're making on this?
Judge, I would ask the court to reconsider reinstating the original bond that he was placed in jail on. He was arrested on a warrant, I believe, probably on a bond that had been set by a justice of the peace. and then was in jail, got out before he ever actually went to court, I believe. And then was arrested when he came up to go to court. And there hasn't been a bond since that time, I believe. I may have left a couple of things out.
Oh, yeah. What's that say?
I think if you take all this, all these other procedural problems out of the equation, I would still be thinking the bond is not sufficient. So that's really where I'm at here now, based on everything I'm seeing.
Because
Well, because of the fact that if you look at what is in the probable cause affidavit, combined with the fact that we know that he's been communicating with one of the victims present at the scene, Gasway.
Gasaway was not one of the, Gasaway specifically gave a statement to the Beaumont Police Department that she did not wish to file charges and was not injured.
She also didn't
Correct.
dispute anything that the sister said. She just said she didn't want to file charges. So I have a very big concern here, given that this is the type of situation that easily escalates, and we come back here and we're dealing with something else.
Even more interesting, Judge, it is not a sister, it is a stepsister, or I'm not sure they have a blood relationship between the two of them, but they're not living together now.
I just don't think that really matters for purposes of what we're here to decide.
What do you understand? Who is the defendant reaching out to from the jail?
Gasway, the wife that did not want to file charges, but I fully intend to call as a witness if we have to try a case.
And she is not a victim in the case, nor is she listed as a victim, although she was a witness. I thought you were talking about Miss Matthews. I've spoken to both of them, but
She is not the named complainant, but she easily could be. I could file another charge with or without her permission.
You want me to read out the probable cause affidavit? That's what we're relying on here. Do you want me to read this out? I'll read it out so the whole world can understand. So we've got the police make contact with Gasaway and Matthews, two females. Gasaway states she was having an argument with the defendant, which led to him coming home locked out of his residence. Gasaway states the defendant broke the door down and Gasaway and Matthews run to the bedroom of their apartment. They both stated they heard the sound of a gun being cocked. A firearm was discovered inside the residence. Matthews stated she observed the defendant point the firearm directly at their heads. Gasaway and Bean, the defendant, began a verbal altercation, which led to Bean, the defendant, grabbing Gasaway by her neck and pinning her to the wall. Gasaway stated the defendant then body slammed her on the bed and held her down. She was not able to freely move. Due to these facts, Bean was arrested, the defendant, for the above charge and transported to the Jefferson County Jail. Okay, that is what we're relying on here. That's the probable cause affidavit signed under oath by Beaumont Police Department, who investigated the case. The defendant is charged with intentionally or knowingly threatening Matthews with imminent bodily injury and used and exhibited a deadly weapon, namely a firearm, during the commission of the assault, which is in line with the probable cause affidavit. What is the indictment? There's not an indictment stating that Gasaway is a complainant in a formal indictment.
That's correct, Judge.
Okay.
I do think that we should have a bond condition addressing that right there, just because we know he's been in contact with her.
With whom?
Gasaway.
Okay. What about that? Mr. Lee.
Judge, we can get into the entire fact situation here. It was his apartment where the incident.
No, I'm
took
talking
place.
about the communications he's having with Gasaway.
I don't see how that is disobeying any order of the court. What he has four
Wait, wait.
children, three children.
Wait.
It's not what I said.
Wait.
Okay.
Hold on. You don't think that's a violation of any order?
Well, contacting her alone made
What do you think?
plus, I don't know how he contacted her, but I'm assuming it might have been by telephone. It could have been that she came to see at the jail because local, but I don't believe, and I'm sorry, I'm probably misinterpreted the point that that the prosecutor was trying to make in
No,
that.
so we're talking about setting bond conditions. Let's get to a bond. We're talking about setting bond conditions that the defendant would follow. Of orders of the court. And what I'm saying is on Matthews is the complainant in this indictment.
Yes, sir.
But what about the communication he's been having with Gassaway?
All right, that's what I was very inartfully trying to address. Jeff. As a result of this, Miss Gassaway basically moved back to Jasper, where she was living with Mr. Bean and three children.
I know, I'm talking about since the incident, since he's been arrested. What's
Well, but I think
his relationship with Gassaway?
I don't think that he has threatened her or anything.
He's communicating.
Well, I'm not sure. I wasn't sure. I didn't understand that he was communicating with.
I thought that's what this.
Yes.
No, I mean, Mr. Eckhart said that he was, and he has more access to the jail phone calls. I didn't know that until this morning.
Yeah, I didn't either. I just looked it up while we were here.
What is it that you know?
Approximately 50 messages back and forth. There's probably phone calls as well. Yes.
Oh. Here's the problem. Okay. I'm taking the word of the prosecutor, and he's a court official just like you. And I'm going to present. Okay, you're not disputing.
I'm not saying that he's not.
I've got to set some orders that he can follow, that I can trust he will follow. Here's a magistrate's protective order
Yes,
that was signed by the magistrate that says you shall not contact or have any contact with Gassaway. If you're going to violate this judge's order, you're going to violate mine. I'm sorry, it's an order that's in the record. Mr. Grove probably didn't know that because this was signed at the time of the event.
I apologize.
And here it is. You can have a copy of it. And it says, among other things, you shall have no communications with Gassaway. And this is signed by Judge Hughes, who signed this protective order on November 3rd of 24, and it's still in effect.
I don't dispute
He
that.
can't follow a judge's protective order. Why would he follow mine?
Again, I apologize. I didn't know that he had been contacting Miss Gassaway because when I talked to him, he hadn't been contacting this guy.
All right.
Hadn't been able to.
All right, we're going to move along.
Okay.
So the court finds that I'm not going to set a bond at this time because he can't follow a judge's protective order. He's not going to follow mine. And until you start following, and until you quit interrupting me, interrupting, you will stay in jail.
Hurt nobody, ain't doing nothing to nobody.
That's all. What are we going to do next, David? I'll set it for trial.
Also, let me see if I can work any kind of resolution, Judge, since we haven't even had a chance to discuss that. And if not, then yes, we'll.
Yes, sir. This has been one of those things where.
All right, see what you can do. But I'm just putting it on a review in 2 weeks. Okay.
Yes.
Review in 2 weeks. Thanks.
Who's next? Who do we have? I think that Bob maybe. What are we doing? Mr. Cook, Richard Cook. You're
Gotcha.
still going through discovery. It's a new case, so.
He was a bond
Where is it?
forfeiture yesterday.
Oh, he's bond forfeiture?
Well,
He was originally scheduled for today,
My office actually asked to move him.
Okay, did we fix all of that from yesterday, or was there a warrant issued for him?
I do not believe the warrant was
Okay.
officially issued.
So what do you,
One more announcement, we'll have the case ready to be resolved.
okay, 4 weeks, you got it. Get a resetting. Thank you.
Just quick approach on Justin Woods. We, this is unlawful carry.
Where's he?
And he's.
Come on out.
This is the first setting I have been into. I apologize for being late.
It's one case, right?
Yes,
24
yes.
CO
I spoke to,
third degree felony, unlawful possession of the firearms by felon.
Yes,
Yeah,
Judge.
and Mr. Chica. Yeah.
Yes, yes.
So what are we gonna do today?
Today, we're asking for a reset just to, we're.
Is 4 weeks good for you?
Discovery, 4 weeks,
Done.
great.
Okay, get a reset.
Thank you, Judge.
You bet. Well, yes, come Jason. No.
And Your Honor, I have one witness besides Mr. Noble that's here. Okay. That's present. Sorry, there, right?
Reset.
Okay, this is the supplemental.
Give a motion.
This would be the line.
Not the right motion.
First would be the line.
You can't do it.
Your Honor, I see that Mr. Noble's remaining case, the Spalding case, is on the same docket. And it says sentencing, but I don't think that's correct.
Just all following
That's-
others.
Just,
Didn't.
how can there be a sentencing when he didn't
Well, I don't
leave? Well, it's an obvious a mistake.
No, I was,
All follow each other, only said it on one.
okay, and I just wanted to
Yeah,
make
so
sure that.
that's-
Well, that's gonna be dismissed, right? Is that what? Oh,
No,
that's
sir.
right. Okay, so this is clause number 39549,
Yes.
this one.
Yes.
And then there's still 37734.
Yes, I would like to keep it.
All right, it's called State of Texas versus Jason Gregory Noble.
Your Honor, should I bring up the other witness?
Here represented by his attorney and the state's attorney, Mr. Rosa is representing the defendant. And the state's attorney is present. Mr. Noble earlier is,
I'll do cleaner disposition.
have you already entered a plea on this?
Jury trial,
Oh,
but
jury.
he opted for you to determine sentencing. If I remember correctly, Judge, there was pleas true as to the
All up with the.
bars. So his exposure is 25 to life.
It was
Yes.
a second degree felony just on paragraph 1.
Yes, sir.
And then he pleaded true to paragraphs 2 and 3. What does that make it, a habitual felony?
Yes, sir.
Okay, 25 on.
Yes, sir.
All right. Pre-sentence report has been tendered to the parties. Any objections or changes to it from the defense
Mayor,
or states?
No, sir.
Okay. The agreement is, again, the courts, it's open to the court for sentencing under the punishment range that is applicable under these circumstances. So what says the defense?
Your Honor, I would ask the court to take into consideration that although there was an extensive history of assaultive type cases and offenses involving violence, I would ask the court to take into consideration that Mr. Noble was introduced to violence at a very young age, 13 years old to be exact, by his father, when he was at a critical developmental age in his life, and began with assaultive offenses as a juvenile as young as the 11th grade. And it's kind of continued on since then. And Mr. Noble has not received any kind of treatment for his anger and his aggression ever. And
How old is he now? How old is he?
51. He's 51.
Whose fault is that?
And I'm not saying that it's anybody's fault.
Oh,
I'm just
okay.
pointing
Well,
out
we
the
wanna know
fact that he has not received any kind of psychiatric treatment or counseling or any help to manage his anger
Oh,
issues.
so
And
it's
on
nobody
top of
else's
that-
fault.
Yes, sir. And on top of that, he also has been diagnosed as being bipolar. And he admits that he was prescribed medication, but he stopped the medication. And I would like to point out that there's never been any kind of medication management or oversight, and that may have contributed to some of the anger issues and his overreaction in the present case.
You're cryptic. What does that mean?
Which part?
There's no oversight and what does that mean?
Well, meaning that he didn't have any help with,
When you're prescribed
Ensuring-
medicine, when you're at home, you take medicine as prescribed. We all do. The doctor doesn't come in and says, okay, I'm going to watch you in video to make sure you do it. We're grown-ups. You're prescribed medicine. You can either take it or not take it. It's free will.
sure,
And if you don't, then if something bad happens because of that, then whose fault is that?
well, Your Honor, I'd like to point out, in Officer Riley's report, that because he was not receiving mental health treatment and going to regular counseling sessions and getting, that they could not ensure that he was receiving this medication.
Why not?
Well, because it's just never been ordered in any of the times that
Well,
he's
wait,
ever
wait.
been on probation.
Hold on. He's not going to regularly schedule doctor appointments? That's what you just said. Whose fault is that?
Treatment.
Okay, okay. Well, who ordered the treatment?
Patients, well,
Was it recommended by a doctor? But you didn't go.
I was traveling time.
What, that's your, whose fault? Okay.
okay. There's also been an extensive problem, extensive history with substance abuse. And I'd like to point out that Mr. Noble has never received any kind of treatment or rehabilitation or therapy relating to his substance abuse issues. He did report that he was going randomly to NA and AA. But the last one was in 2018. So taking all of these things into consideration, I would ask the court when it discusses the sentence that it show leniency. Mr. Noble, on the date of this offense or the date that this offense occurred, he truly believed that what he did by trying to disarm Mr. Knighton with the weapon, that he was saving his life and his mother's life. Based on the fact that, according to Mr. Noble, as it came out in court during the trial, Mr. Knighton had discharged the gun prior to that evening when he was high on methamphetamine. Or methamphetamine. And so, Your Honor, even though he did overreact, the injuries were severe, but he truly thought that he was doing what was necessary to get the gun away from Mr. Knighton. And in the supplemental PSI report, Mr. Knighton himself states that he has forgiven Mr. Noble, that he actually resided with him when he was out on bond after the current offense. They've set aside their differences. They call each other, or Mr. Knighton and his mother have continuously contacted him and spoken to him on a regular basis. And although they did not appear. And I'm not making excuses for them, but they really did not want this case to go forward. And unfortunately, it
Why do
did.
you think?
Well, because he didn't think that he should serve any more time, that he's already served time, and that's according to what's in the PSI report. It's time served. That's what it should be. So the victim himself is telling the court and everybody that he comes into contact with, in addition to signing 2 non-prosecution affidavits, which, never came out because they didn't appear. He didn't appear in court. He has consistently held the position that he did not want Mr. Noble to be punished for this. And why would a person do that? It's not because he was scared of him.
I'm sorry, the victim, as we recall,
Yes.
had the gun, the barrel of the gun imprinted on his forehead.
That is correct, Your Honor. I mean,
Gee.
and I'm not
Well, what do you-
downplaying the injuries.
What do you think could be reasons? Maybe a victim like that. This court has never seen such a thing. Never seen. Somebody had to jam a hot metal. The gun had been fired in just a few seconds, stuck up against the forehead and burned into the man's forehead. The barrel of the firearm. How ruthless is such a thing? How ruthless. They had to think the next moment the trigger will be pulled and there's no escaping it. A bullet goes through your brain.
Well, Your Honor, I'd like to point out that at the time that the gun was used to hit Mr. Knight in the forehead, the chamber or the magazine had already been expelled and the bullet in the chamber had been ejected. And then that's according to his own testimony, and it was found in his pocket. Mr. Knight.
So play down the fact that he puts a burning hot piece of metal in the man's forehead. Play that down, would you please? That is as mean-spirited as it gets. What? Okay. Oh, so was he doing it for fun? No, he was doing it to hurt the man. It was just an act of meanness.
Your Honor,
You were-
can I call Mr. Noble? He would like to address the court, if you would give him the opportunity.
Yeah,
Noble.
that's you?
Yes, sir.
Raise your right hand. You solemnly swear or affirm testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Lower your weapons. Go ahead.
And I just want to apologize, Jill Stevenson, for wasting your time at work time. I did not want to go to trial in this case. I was in Mr. Hand has made an offer to me. My stepfather, he comes to see me regular up here in Jefferson County, in there 2 years. And I told him that the offer was 20 years. And they told me, do not sign for 20 years. And I was legislative leave with the offer was for 20. We have forgiven each other about the altercation. But if he was just saying just 2 seconds ago about the pistol thing, my stepdad did fire a firearm previously about 2 weeks prior to this inside the house. And it really scared me, scared my mother. And there's a lot of other episodes.
So it's his fault.
No, sir, it's not his
The
fault.
jury found otherwise, you know that.
Yes, sir. I'm going to respect the jury's decision too.
All right. Let's respect the jury's
Yes,
decision,
sir.
finding you guilty of aggravated assault, family violence.
Yes, sir. And there's no excuse for me acting like that, behavior like that. There's no, I understand that. But I guess I overreacted in the heat of the moment.
Which time?
What happened?
What about your prior convictions, which are crimes of violence? Let's see, arson,
Yes, sir.
and what, after that, aggravated assault, another aggravated assault. You were convicted of that in 2010. How many violent crimes do you get before you're held accountable?
Yes, sir.
And I'm looking at your criminal history.
Sorry.
How many convictions do you have?
She said I had several misdemeanors.
No, no one should know more intimately about their actions than themselves. How many convictions do you have?
I have 3 felonies. Prior convictions on like she's 20 or 30 misdemeanors.
You see anything wrong about
Yes,
that?
sir, very wrong. Very, very.
After all of those, now you're here before the court for another crime of violence. After 20 some odd convictions. You don't, we all see a consistency that should have been dealt with 25 convictions ago. You should have learned a lesson. Okay.
I'd like to call Philip Jones, who is a childhood friend and boss / coworker of Mr. Noble.
Come on in. Come on in. Where that person is, that's who that is.
Yes.
Okay, what is your full name, sir?
Yes, Philip James Jones.
Raise your right hand. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Lower your hand.
Uh,
No, this question and answer.
okay, all right.
Go ahead.
Mr. Jones, your name is Philip Jones, is that correct?
Yes, ma'am.
And how long have you known Mr. Noble?
Since he was probably 12, 13 years old.
And
How long?
12 years old.
Yes.
since Mr. Noble was
I'm a
12 years
little,
old?
yeah, I'm a little older than him.
Your childhood friends? And did Mr. Noble work for you at one point in time?
Yes, ma'am.
And what did he do?
He was a foreman, supervisor,
And what type of job was this?
scouting.
Okay. Now, did you ever witness any violence in Mr. Noble's household when he was younger?
Yes.
Could you describe that?
Well, I can tell you, like, when we were kids, we were going to fight it out. We'd go to fight it out in the backyard. And if we did something wrong, we would get a whipping. When he was a kid, he would get beat up by his dad, with his fists. And, so.
Okay,
Oh, well.
I'll be there.
uh,
When you say he was beaten up by his dad with his fists,
Yeah.
can you be a little more specific? Like where his dad punched Mr. Noble?
Yeah, his dad would, he would just basically take him and beat him, punch him with his fists in the face, in the back, wherever he turned. And then he would get away and never goes and we could like,
Okay, now, Mr. Noble's father committed suicide when his father was 45 years old, is that right?
right.
And how old would Jason, Mr. Noble have been?
He would probably, well, he was in prison when that happened.
Okay, so he was an adult,
He was in the, yes,
okay.
27.
correct.
Thank you. Okay. Is
No,
there,
it said, wait, hold on. Your father died at 2001 at the age of 45 by suicide. Just with this stage. I'm sorry, you were born in 74. So that's 27 years.
I thought it was
There's
twenty.
a-
I should know more about this than you do. Go ahead.
is there anything that you would like the court to know? Well, let me ask you this. Did you ever know Mr. Knighton, the complaining victim in this case, to use drugs?
Yes.
And how do you know that he used drugs?
I know that he used drugs. He had my nephew and his Jason's son shoot up drugs when they was a kid. And so that's back when Logan and Caleb were young. Logan got into some trouble with Kim, and they were shooting up. He was shooting them up with cocaine, not cocaine. I think it was crystal meth at the time.
How do you know that?
I don't know that. Logan is my nephew.
Okay, and
And Logan's mother is the one, that actually that made them get away from there because of what was happening with them doing drugs at Jason's mom's house.
Well, Well, what did the adults do about telling the authorities so that someone could be held responsible?
No,
You don't really know. You were a kid.
Well, no, I wasn't a kid. This is Logan is my nephew. This was
this
Logan is
I'm talking about when you were watching him.
no, he was in prison when this happened.
Okay.
When Kim was doing drugs
Okay.
with Jason's son.
Okay, so what adult figure needed to talk to authorities to, that's a
That would have
crime.
been Logan. That would have been Logan's mother. Yes, yes,
But other people knew about it, right?
yes. A lot of people knew about it,
But nobody-
I don't know that they filed any charges on him for that. No, I do not.
Now, the night of the incident, were you contacted by,
Jason's mother.
and Jason's mother is?
Yeah. That's his mom.
Okay, so this is night.
Yeah, that's Mrs. Knight. Yeah, I know her for Miss Noel.
She has your phone number
Yes,
and she contacted you.
right.
And what was she wanting you to come over for?
She was wanting me to come over to calm Jason down
Okay, go ahead.
because Kim had fired off a gun and then Jason tried to take it from her and hit him with the gun and that.
So did she tell you that Kim had fired a gun? And that Jason,
Objection, that's a hearsay response.
Sustained.
present sense impression exception, Your Honor.
Overruled. It's hearsay. There's no way that this can be tested by cross-examination.
Your Honor, if
I
I
made
may,
my ruling. Thank you. Move on.
no further questions, I'll pass the witness.
Anything from the staff?
I have no question to this witness.
If you wanted to add, sir?
Yes, sir.
Go ahead.
I've known Jason all his life. He has, had a little rough life. He's always done anything for me, and he's always, and the whole time that I've known him, he'd give me a shirt off his back. He'd give any one of his friends a shirt off his back, and he would protect you like you were his father. If you would, just like he would have protected his mom that night, he would protect you. I can tell you, he stayed with me for almost a year and a half after he got out when I bonded him out. My grandkids love him. They miss him to this day. He's a good person. He needs some help with his anger issues. He's never gotten to deal with that. But I can tell you, he's a good person. He don't deserve to go through the rest of his life.
Wouldn't you agree that a person really is judged by the decisions they make?
Yes, sir. And I can tell you, my mom was murdered by her husband, beaten to death. And I wish I'd have been there today to take that from him and kill him instead of him killing him.
Oh, I understand. Self-defense is
Yeah.
under the law.
So you have to.
But the
also
defendant,
take-
I'm looking at, the defendant has been convicted. He's been convicted of arson and was sentenced to 20 years in prison for arson. An aggravated assault, sent to 8 years in prison in that case. That was before this one. All right, then we're talking about, he was convicted of terroristic threat, harassment, family harassment, convicted in misdemeanor court, sentenced to jail in those, assault, family violence, assault, terroristic threat, assault, family violence. All those were convictions. Don't you think that this is a consistency of bad choices? We're talking about violence, crimes of violence. How many mistakes do you get to make before you realize, this isn't the right choice to make? It's a tough.
I totally understand that.
I know.
And I know about a lot of those cases, especially the one with Carl Kruger that.
I don't know. I don't know who people are involved in this. I'm just looking at his convictions
And,
which stretch back to
And I mean,
the 1992.
and what I'm asking, can you give him a little help? You know what I mean?
Well, first of all, the help needs to begin with the person who's who's been making a mistake for
Totally
for
understand.
33 years. 33 years as an adult. I mean,
I'm a dog.
it's like you and I, we're all judged by the choices we make. And when we put our hand on the stove, it burns us. We go, we're not going to do that again.
Well, I'm not asking you to make him a better person. I'm asking you to give him a chance to put him in a type of program that can get him to a better person instead of going to.
What are you suggesting is going to change his demeanor?
Whatever suggestion is going to.
What do you suggest?
I suggest counseling with
What kind of counseling?
mental counseling.
What is wrong with him that you are aware of medically?
What am I aware of is medically that he don't take his bipolar medicine. The only reason he couldn't take it whenever he was at my house because he was in between jobs and so I can tell you as a standpoint, if you don't have the money, how can you take the medicine? You know what I mean? And then if you go in and off on that's a whole other way out of
Yeah.
my belief.
Okay.
But I can tell you that working through your mental problems with some type of counseling is better than going and fighting.
I understand, sir. I
You know what I
understand, but I don't know why things weren't done 33 years ago. And here we are.
I can attest to that.
Here we are. And we're cleaning up messes from 33 years ago that adults should have handled a long time, responsible. Oh, I don't know. It's frustrating for us all.
Yes,
I mean,
especially when you love them first.
all right. Is this man
Things that they don't.
really excused? Is this man excused?
Yes.
Okay, thank you. sir.
Thank you.
Who's next? Who's next?
That is all I wanted.
Okay. Go ahead. Estate, did you have anything you want to add? What's everybody arguing for here on?
25 years.
Go ahead. Is there anything else you want to add?
No, you're
Judge, I appreciate Mr. Noble's friend showing up and speaking for him. However, the truth is that he was interviewed by law enforcement, never offered any of the comments that he made today about who said what, when, and where. All that's just another great example about how Mr. Noble has done everything he can to try to manipulate the system. Let's start with his victim in this case. He did come to my office and he did give me a affidavit of non-prosecution.
You're talking about.
I'm talking about Mr. Knighton. And that, as is my practice, whenever someone comes to the office with an attempt to try to drop charges, I visit with them. And one of the first things that I ask them is, did these accusations occur? That's routinely what I do every time. And Mr. Knighton said, yes, it happened. I have to have some peace at home. The only reason why I'm doing this is because my wife's making me do it.
Jack to the hearsay, Your Honor.
Okay, sustain.
So the reality is, after his state confirmed that the accusations were true from Mr. Knighton, so that's why I proceeded forward. He was represented by different counsel. They went through other efforts. They actually brought Mr. Knighton in. They got him to do a different affidavit saying that those things didn't occur. But the facts are what the facts are, and that's what was presented to the jury. These arguments that he makes today about trying to disarm them and discharging them, that he allegedly overreacted, all those arguments were presented to a jury and were found lacking. They found him guilty. And what we see here today is just another situation where Mr. Noble does not accept responsibility for his conduct. Even his counsel's argument starts out blaming his father, which you heard from Mr. Jones, about his upbringing, that he's never had any treatment, that he's made his own decisions about whether or not he's going to take his medication. The reality is that he committed this offense, Your Honor. I'm happy to note, recalls all the details about the pure meanness of this particular act, that a gun that was fired was then jammed into the victim's forehead. The only way we could have gotten those injuries is if it was hot from that shooting. You'll recall that the man was sitting in his chair and there were bullet holes by where he was sitting, all fitting what he told officers on scene. Those
Object, that's incorrect. That's a mischaracterization of the evidence. There was only one bullet hole that was found, and that was by the forensic analysis or analyst that testified.
there were 2 bullet holes. The argument was whether or not there were 2 or 3 bullet holes, and the record will speak about that. So the end result is, again, it's just not accepting responsibility. If we're going to give somebody leniency, if we're going to give them a break, we look to determine what's their conduct. This man was out on bond on a stalking charge. I'm not going to address whether or not those charges are true or not. What I want to address is the fact that he was indicted, he posted bond, and what did he do? By his own admissions in this PSI, he continued to use methamphetamine all the way up until 2023 when he went into jail. That does not comport with your bond conditions, nor does it's meth is against the law. It's continuing breaking of the law. So if we're looking for leniency, wouldn't somebody's conduct be different? His own records indicate that this man is a menace to society. He has let me count, Judge. He has 8 misdemeanor convictions. Of those misdemeanor convictions, 2 of them were given an opportunity to do probation, which were revoked. In addition to that, he's got 2 felony convictions, all of which I was prepared to prove up to a jury because I did not know they were going to you until the morning of jury selection. Both of those priors, he did not admit to the offense. He was found guilty by juries in each one of those scenarios. And those sentences that are reflected there is what a jury decided. For some reason, he made the option to switch over and allow you to make the decision. It's 25 to life. It just goes to how this man has manipulated the system. We issued writs of attachment for the Knightons to bring them down here. I was prepared to prove it up without them, and I did. But the entire time that the trial took place, we were searching for those people. We were monitoring the jail calls. There was contact between this man and his mother constantly about the trial, all throughout the trial while it was done. And so what happens after we get done? We get a PSI that says they couldn't get a hold of the victims. But ironically, before we start this sentencing, they knew about the fact that it had been updated. I didn't. You're giving that.
That's objection.
If I may.
That's incorrect too. I did not learn about that until today when Mr. Noble told me.
Thank you, because that's the whole point. Mr. Noble knew. Mr. Noble knew. Mr. Noble did the conduct. Mr. Noble's history is on trial here. Mr. Noble has done everything he can to manipulate the system, including bringing up his childhood friend. The day of accounting is
This
today.
supplemental report, this was information that the officer received 3 days ago. 3 days ago, so it's new to everybody.
All right. One other thing out of his history. He was given a federal sentence, Judge. So he pled true to what's in front of you that doesn't include the federal sentence. Why I want to point that out for a second is it was not a very lengthy sentence, but as Your Honor is familiar with, whenever someone gets a prison sentence in the feds, they get supervised release. Similar to our probation, but it's post, right?
Mm-hmm. Yeah.
He couldn't make those terms either, Judge. That was revoked. So when you weigh it all out and you separate all these things, we're looking to determine, what's the safest thing for Jefferson County. 12 of our citizens disagreed with the arguments that he's made today. They held him responsible without having heard from the victims. They know that the exposure is 25 to life. I am asking that the court sentence him to 40 years.
Okay. You have a chance to rebut. Go ahead.
Your Honor, I would just point out that Mr. Noble is not trying to manipulate the system. He's doing what he has rights to do. He's calling witnesses to testify on his behalf. He admits that his actions that day were wrong, that he overreacted. He understands that. So he's not escaping accountability or trying to say that he's not sorry and remorseful for the way that things occurred. And so I just want the court to be aware that the statements made by Mr. Ham are incorrect. And that's all I have, Your Honor.
Anything else you want to add, sir?
Yes, sir. I'm really sorry about all this. And I know this is very serious. And I didn't tell Philip Jones nothing about coming today. He did it on his own. I didn't. And my mom came to Wednesday in visitation and told me that a man named Riley called. I had no idea what was going on. And my mom said that my stepdad had talked to him. That's how I knew about that situation. But Your Honor, if you send me to prison for a long time like that, I don't know how I'm gonna recover from nothing like that. And I mean, I've been in prison twice, and I tell you, it's just no joke. It's tough. It's hard.
It's supposed to be a
Yeah, I'm just saying,
punishment.
it's just nobody's down there happy. It's all nothing but a bunch of angry people. And I just think it'll make me way worse if I'm sending me to prison for a long
There's a
time.
way to avoid all of this,
This is what I feel.
not to commit a crime.
Yes, sir.
That's what we're here on. But it's a similar crime that you were convicted of before. Aggravated assault. I mean, that's the problem is you're supposed to learn, we got to stay away from this. Like it's the bubonic plague.
Yes, sir.
It has its consequences. And then this offense was committed in real inhumane fashion with the gun being, that was just an anger act. I mean, that's meanness. It's not the way you're supposed to treat anyone, much less a close relative. Right?
Yes, sir.
Someone you're supposed to love. What would you do to someone you didn't like? We had 9 prior misdemeanor convictions and 3 prior felony convictions. 2 of those felonies, violent crimes, arson and aggravated assault. And then terroristic threat, harassment, assault, family violence, terroristic threat, assault, family violence. It's 1, 2, 3, 4, 5, 6, 7 other acts of violence. You don't think it's time that you stop committing acts of violence? Anything else? If nothing else, I find as follows, that the defendant has pleaded guilty, has been found guilty beyond a reasonable doubt of this aggravated assault, family violence as alleged in this indictment. Thereafter, being found guilty by a jury verdict, the defendant entered pleas of true voluntarily, knowingly, intelligently to the allegations of prior convictions in paragraphs 2 and 3 of the indictment, where it's alleged the defendant was finally convicted of arson on February 1st, 2001 in the 252nd District Court of Jefferson County, Texas. Thereafter, that became final. The defendant committed the felony of aggravated assault and was finally convicted of that felony in 2010 in this court. And then subsequent to that, he is charged and convicted with the March 17th, 2022 aggravated assault, family violence. So the court finds that there is sufficient evidence supporting the finding of guilt beyond a reasonable doubt, and paragraphs 2 and 3 are proven true beyond a reasonable doubt, which puts the defendant in habitual offender category of sentencing. So he's looking at no less than 25 nor more than life, up to life, 99 years or life imprisonment. That's the punishment range the defendant is looking at. If nothing further to add by anyone, the defendant has been found guilty of this offense, is subject to this punishment range of habitual offender status. The defendant is hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 35 years. And the judgment shall reflect that an affirmative finding shall be made that a deadly weapon, namely a handgun, was used in the commission of the offense. You understand what has happened today, sir? Anything else?
No,
That is all.
thank you.
Here's this. Thank you.
Andrea Danielle Rich, 25F243816.
Good morning, Judge. Matthew Gates on behalf of Ms. Rich.
Ms. Rich, your name.
Andrea, right?
All right, now this one scares
I know.
me. Well, I'm just telling you. I don't want to make a mountain out of a molehill. The scored almost a 2-0 on the blood draw. You're not even legally able to drink. Now, I don't keep statistics up here, and I'm certainly not going to go research statistics that I'm going to know are not probably very reliable. But I'm telling you, I've been doing this long enough to know that when people have this kind of breath or blood result, guess what the likelihood is of coming back in front of me or another judge, either in this court or another court, in the next 3, 4, 5 years. And oftentimes, many cases, 2-0 with 20 is really high. You had a 197. No more. We got one another? Do we? Do we understand one another?
Oh, of course.
You're making good enough money. Take a cab, take an Uber, take a Lyft, have a friend drive you, walk, take a bike, take a helicopter. I don't care, but don't drive a car. Okay? All right, that's all I'm going to say about it. Counsel, have you reviewed the pre-sentence or screening and assessment? I should. And by the way, does she have her AA verification?
Yes, sir. Yeah.
Have you shown it to Mr. Gates?
Show it down.
Yeah, have you shown it to him today? Take your time.
Yes, I got a chance to review it.
Okay. She's been going twice a week. True?
Yeah.
Is that right?
Yeah.
Okay, go ahead. Have you reviewed the report? Any material additions, corrections, or deletions?
We have no material additions, corrections, Judge, or deletions. I would like to say, however, with regard to recommendation number 10, we'd ask the court to change that from obtaining GED or high school diploma to full-time employment, Judge.
To say what?
Say,
You're objecting to her having to obtain a diploma or a GED?
Judge, based on what she's told me, going back right now, re-enrolling or obtaining her GED would cause her to lose her job, which she needs to help pay family.
How would that cause you to lose your job to enroll to get a GED? Listen to me.
She works full-time 5 days a week,
So what?
8 hours.
Everybody works full time, at least those who want to work. I mean, or unless they're disabled. I mean, you got to get a GED, young lady.
I understand.
You're making $785 biweekly, right?
Yes, sir.
Guess what? If you don't get a high school diploma or a GED, except for inflation, you're going to come back here in 20 years and you're going to be making $1,000 a week or biweekly. You don't want to live in poverty, right?
Yes.
You don't have any children. You live with your dad, right? You're working 40 hours. Yes?
Yes, sir.
Okay, I'm not trying to scare you. I don't want you to be nervous. But that's not a lot. That's not a lot. I'm not saying you're not working. Okay, that's great. I give you credit. Nobody's going to tell me they can't get a GED or a diploma if they're only working 40. Now, if you told me you were working 85, maybe I'd understand. I'm going to order you to do that. Okay, it's best for you. Someday you'll come in here when I'm older, or when you're older and I'm not gone yet. And you can say, Judge, guess what? I'm running Ford Motor Company. I got that GED. I'm serious. I'm not saying you're going to run Ford Motor, but you got to set your sights higher on this. You cannot leave high school during the 11th grade. You don't want to be dependent on some man or anybody else, right? Right? You seem like a nice kid.
Judge, if I may, there's been family circumstances where she ultimately ended up raising her 5-year-old sister from the time she was born, 6 months old, because her mother had some issues. So she took full responsibility for that child.
Okay, I'm not saying she's anything but a nice kid. There's no reference to that in the, there is a reference that she left high school to care for one of her parents, it says. But you're saying that was a sibling.
It was a sibling.
Yes, it was
My
my mom's child.
I'm not trying to make you feel bad. I want to make sure that you do better. Right? Right? Okay. Anything else?
Just that she has no prior criminal history, Judge, and we ask the court to adopt the recommendation.
So you work Monday through Friday?
Yes, sir.
You're a very respectful young lady,
Thank you.
which is a very good thing. That will take you a long way in life. I don't get the feeling that you're here thinking that you're picked on or anything along those lines. Look, I'm going to place you on probation for 14 months. I can't go along with 12 when somebody who's 20 has got a 20. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. They're recommending monthly testing. I just can't go along with that. Frankly, with what I see here, it should be weekly. I don't want to do that because I'm not going to bankrupt you, but I am going to make it at least bi-weekly. So you have to go for testing every other week, and I expect you not to miss. Bi-weekly for 3 months. If you're clean, then I'll make it monthly for the duration of probation. No kratom, no poppy seeds, no CBD oils. If you consume any one of those things, and that will be deemed a violation of your probation. I want you to obtain and maintain employment and provide proof. Obtain a high school diploma or a GED. Attend AANA at least twice a week until you're in outpatient treatment. I'm ordering outpatient treatment. Once you get into treatment, you no longer have to go to AA or NA. So if you started tomorrow, you don't have to go to AA or NA any longer. Also, you have to go to the Victims Impact Panel, which is one night put on by Mothers Against Drunk Drivers. Do you understand that?
Yes.
They're recommending 90 days continuation of the Sober Link. I hate to charge it, make you pay all that, but I find it necessary. I'm not going to make it 90. I will make it roughly 60. You have to keep that on until August 1, August the 1st.
Okay, thank you.
All right. Now, five days jail credit 1, serve 4. I'll let you serve 2 days on our court work program and 2 days of community service.
Yes.
Court work program, there's a $35 a day charge for that for a total of 70. The community service, you can do at any nonprofit organization of your choosing. Salvation Army, St. Vincent de Paul, I could care less. Animal shelter, church, doesn't matter. You do that, I'll give you all the way until July the 31st to complete that. Fines are $300. costs are $200. $75 victims' rights fee, $50 justice assessment, 6 1/4. Screening fee 60 for 685. Probation fees are 280 for 965. Cost of recovery is 225 for a total of 1190, and you have court work program fees of 70 for a total of 1265. Plus, I am going to charge a minimum here. It's going to be $40 in attorney fees. I think, didn't I say 1265, Lisa? That should be 1305.
Because it should be 12, it should be 13 even, I believe.
I didn't remember if I said 1265 or 1260. Let me just double check. 6 1/4, 685, 725, 925, 1005. It should be 1230 plus. Wait a minute. Let me just see it again. 6 1/4, 685, 885, 965, 1005, 1225. 1230, 13 should be 1295. Yeah, you're right. It's 1300. My apologies. You may be eligible for early discharge. Okay.
Okay.
If you comply with everything and there's no violations in the preceding 90 days, you come in here in 7 months, and by law, you're entitled to have your discharge. Do you understand that?
Yes, sir.
If you violate, you could get 90 days. You have 21 days, 93 days with credit for 1 day served. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer. Do you understand that?
Yes, sir.
Any questions?
No.
Okay. I don't presume you have most of this or all of this to pay. So you can tell me if you have anything today, and you can tell me what you can pay in terms of the payment plan. I don't want to bankrupt you. If you want to tell me a figure, I'll be glad to work with you. Tell me how much you can afford weekly or bi-weekly.
Okay, so tomorrow I do get paid and I can pay you $400 to $500
I don't know. You're only making 785 bi-weekly.
I want to get it paid off. I don't like owing things.
Well, here's what I'm going to do then. Here's what I'm going to do then. I'm going to start $100 bi-weekly. And we're going to start that beginning on June the 2nd. But if you want to pay more, feel free. If you don't have the money to pay more, you don't have to. If you need more time, you call the court. We'll go on Zoom at 8:30 in the morning, on or before any of your due dates, or you can walk in here on or before your due date and ask for an extension. I'm going to do it. Okay? See how easy we are to deal with here at the 33rd District Court, John? Young lady, good luck to you. You seem like a very nice kid. Use your head now, okay? You're going to get that diploma at GED, right?
Yes,
One
sir,
of the
I
two.
have to.
I know, and then you're gonna be glad that you did that. Okay?
Yeah.
Good luck. Thank you. And you're gonna meet with probation before you leave. You too. Sullivan Johnson. Deontay Ryan Sullivan Johnson. 22F 237-314A. 20W826226A. 20W826226B. And 20W826226C.
Good morning, Your Honor. Mike Hill, Problem representing Mr. Sullivan Johnson Association and the record. Yeah, thanks, done.
Mr. Johnson. You. I have a note here. It says, Will, the court officer out front, told me this gentleman in the back of the courtroom gave him the middle finger. You didn't do that, did you? I got surveillance cameras here. We can figure it out. Did you give him the middle finger? You didn't do it. Because you were chirping in here in the beginning of the morning. I said you were chirping in here in the middle of the morning where I had to tell you to stop and said it was childish. Stop. Because they told you to go to the wrong place. Let's assume they did. Do you think there's some conspiracy here? You go over to the local 7-Eleven 7.3 miles away. You think they want to do that and ask and intentionally tell you to go somewhere that makes their job and their life harder? I just want to know if you think that. If you do, there's nothing I can say that will make you change your mind or change your attitude. But this stuff about even somebody thinking you popped in the bird, and I know how you were acting here this morning. And the funny thing is, I got to tell you the hilarious thing here, Mr. Sullivan Johnson, before we go on. I look at these, you know what it tells me? This guy has no respect for authority. I mean, I don't know if you're chief of staff to the president or secretary of state or in charge at the Pentagon, but this tells me you've got no respect for authority. And that's okay. There's some like you. You're going to go through life miserable. I don't know what to tell you. But you're not going to come in here and disrupt the courtroom in the beginning of the proceeding. And you're not going to pop people the bird. Do we understand one another? Listen, I can't hear you.
Yes.
You might do. Yeah. He's going to come in here and tell me 47 reasons why he hasn't paid, why he didn't show up, why we're still playing around with cases from 2020 and 2022 and 2021. I just don't know if I shouldn't just reschedule this because honestly, I'm not in the mood to hear this nonsense right now. Not from somebody who acts like that. Does he work?
Well, Your Honor, he does have a job.
What
He
does that
hasn't been able to start because
He doesn't have a job then. If he hasn't started, he doesn't have a job.
well, he's been hired, but he can't start because of these warrants he filed.
When did he last work?
Sir, when was the last time you worked before this?
I can't hear you. You got to keep your voice up.
Yeah, beginning of May.
Where?
DLG.
I can't hear you.
DLG.
DLG. And when you left there in early May, how long did you work there?
2 years.
Okay. And where did you work before? Let's call it roughly May of 23. How long did you work there?
A year and a half.
Did you go from one job to DLG pretty much right afterward?
Yes.
So you've had a job for 3.5 years and you paid nothing on those tickets, it doesn't appear, right? Why?
My son, he had seizures and stuff, so I've been taking care of him. He's doing that with his mom.
I cannot hear you. I mean, maybe my hearing's going bad. You got to keep your voice up, son.
Okay.
Speak into that microphone and act like you're talking to somebody on the other side of the wall there.
My son, he had seizures and stuff.
Okay.
I was taking care of him and going through the problems with his mother.
Going through what?
The problems that we was having with his mother.
Okay. Mr. Sullivan Johnson. I don't know what to tell him, counsel. If he thinks he's walking out of here today, he might be shot.
Your Honor, that explains my
The funny thing is, though, why would somebody come in here who's been so neglectful about taking care of his court business and then act like he's, I don't know, the most important human being, at least in the Tri-County area? You better go talk to your lawyer and you better figure out how we're going to resolve this. Because I'm done giving you chances. I got things going back to August of 21. Failed to appear for contempt hearing. Said 282 cash bond. Defendant must appear in person. This is August 30. Because he could not appear. It looks like he couldn't connect by video. And then we never saw him again, except he didn't show up for a show cause again in October 21, June 22. And now you want us to do you a favor and clear your cases so you can get a job.
Right. Yes.
You haven't been here for 3 years. You know what the standard is, whether your failure to pay was with or without your fault. I can lock you up for quite a while right now. I don't look forward to locking people up. But then again, I don't like them treating the staff like they're pieces of garbage either. I mean, you come in here, I don't know where your attitude is, buddy, but you're not going to play around and talk in the back here and act like you acted when you came in here. So we're going to start over. I'm going to let you go talk to Mr. Crawford, and I'm getting off this bench. And then you and I are going to have a conversation, but you better take your arrogance level from a 10 to a negative 1,732.5. You got it?
Yes.
Good. Then I'm going to come out here and be nice about it, but don't pull that nonsense with people in here. Everybody stay seated. What's your name? Who's got the case here?
Josh, I got it.
Okay. I'm gonna take a break. We've been on here all morning since about 8:30 or so, and stay seated, everybody.
I believe so.
People against Deontay Ryan, Sullivan, Johnson, 2LW 826-226A, 22F 237-314A, 2LW 826-226C, 2LW 826-226B. Counsel, your appearance.
Michael Crawford, representing Mr. Johnson.
I'm going to sentence him on the suspend charge. That's 226A. He was never sentenced on that, believe it or not. The plea was taken back in 21. But I am going to address these 2 contempt charges. He owes $362, including his clearance fee on the no proof of insurance, Mr. Crawford. That's 226C.
Yes.
So he would owe $315, not including. He also owes on the 226B file $269. There is no clearance. So tell me he's going to pay those, so I don't have to go through a contempt hearing you off and on.
Well, you're right. My client doesn't have the money to pay it.
He's got a big problem. So we're going to get a hearing, or is he's going to plead guilty? Is that what you're going to do?
Let's speak. Yes.
Now I want you to understand. You could get in this case 32 days. You understand? You got to go a lot louder. I'm not.
Yes.
This isn't a hearing test for me.
Yes.
You're going to go, and then if you plead on the other case, show 269, you could get 27 days. You understand that?
Yes.
You have the right to a hearing. At a hearing, you have the right to question their witnesses, to bring in your own. We use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. If you plead guilty, you're giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. So to the first one, the charge that you failed to pay $317, and this again is on file 226C. How do you plead?
Yes.
You failed to pay,
No, I'm not able to pay.
but you failed to pay, correct?
Yes.
To the charge you failed to pay 269 on file 226B. How do you plead?
Guilty.
Did you fail to pay?
Yes.
Anybody force? Did you fail to pay on those?
Yes. I
Anybody force you to plead guilty?
No.
Plea is accepted to both charges. I'm still going to sentence them on the suspend too. Are you ready? Is there anything you'd like to say? And on the suspend charge, I'm going to arraign you, the first one, I should say, the one I did sentence you on, 2373148. I'm going to arraign you for failure to pay $450. If you plead guilty, you could get 93 days. Do you understand that?
Yes.
And you understand your rights? You understand the fact that you have the right to a contested hearing?
Yes.
You understand if you plead guilty, we're not going to have a hearing?
Yes.
You wish to plead guilty, or do you want to have a hearing on this? To the charge you failed to pay $450, how do you plead?
Guilty.
You fail to pay?
Yes.
Anybody force you to plead guilty? Please accept it to that, and now I'm ready to sentence him on the other suspend charge. Anything else?
There's nothing to add to the court.
Sir, anything you'd like to say?
I apologize to the court for wasting time.
You didn't pop your finger at me. If you had, you'd be in back there. So you don't need to apologize to me. 100 fines. This is actually on a no ops sentence. 100 fines, 100 costs, 75 victim rights, $50 justice assessment, 3 1/4 or 60 days. So we've got a real dilemma here. He's got a dilemma. Why has he not paid anything if he's been working for 3.5 years?
My understanding is he's been overwhelmed with costs of taking care of his ill child and going through whatever custody issues he's had with the mother and trying to manage.
Where does he work again? Or where did he work? Until the beginning of May.
I guess.
I thought you said it was DLG or something.
Yeah, that's the name.
How much you making out?
I was like 18.
Why didn't you come in here and pay anything on these?
I was paying my other tickets too. I had
What other tickets?
and 36 district and I had a lot of tickets.
And he's taking care of tickets in Farmington and Romulus and 36D.
He just used us for last. We
only had so much money.
I got it.
But he brought us up the other day. He knew he'd be in trouble. He tried to.
Yeah, he came in here acting like King Kong.
That is unfortunate.
I mean, you can't act like that. Have you had a problem with respecting authority your whole life, or is this just something that happened in the last 3 hours?
No, that officer was being disrespectful.
How is he being disrespectful?
First, he was being rude when I was walking. And when the clerk told me where to go, I went back there. He kept following me.
Who?
The sergeant who said I put up the military.
You mean the gentleman in the front at the desk?
Yes.
Mr. Crawford. As much as he deserves to go to jail, and he is going to end up in jail if he isn't moving on this a lot more. I'm going to give him 1 month to come up with all of these fines. I'm going to give him 1 month. Don't you ever come in here and treat people like that again. Do you understand?
Yes, sir.
They don't have problems with people around here. I'm going to set a sentence date. I'll tell you what. I'm going to have you pay this one. You're going to pay on the improper pass. We'll set a sentence date. Lisa, I want you to put this out about a month.
You just sentenced him, so you want a sentence date on?
I mean on these civil infractions. So I want to give him time to come up with some money so I don't have to lock him up for 50 days.
June 26th at 8:30.
How much you gonna be able to come up with by then?
Don't really have to. I'm doing it.
Remember, he's not working right now. He's going to start it.
I got it. I get it, but I'm setting all of those for June 26th at 8:30. I need to see an effort. So far, I've seen no effort. If you show me an effort, I can assure you I'm not difficult to get along with. If you show me no effort, then I'm going to be difficult to get along with. I'm going to say on the other case, the suspend charge that was reduced to no ops, you're to pay 40 per week. And I'm going to start that beginning. Lisa, give me the first Friday in September, believe it or not.
September 5th.
So it's September 5th. You're gonna work on paying the rest of these until then. You're never gonna have a license if you don't pay these. I'll let you pay 40 per week on that starting September 5th. I'm gonna save some money. You come in and talk to me on these others. And I'll be reasonable with it. Do not, I would strongly suggest, come back with the same attitude you had this morning. Okay, we got one another?
Yes, sir.
All right, go save some money, get a job. I don't remember you telling me something about an ill child before.
Yeah, this is my newborn son.
Geez, I'm sorry. Good luck. We'll see you back here. Go down and get your notice. Thanks.
Good afternoon. I'll let this run for just a moment. As I mentioned this morning, Judge Patterson's gone. Two of the magistrates are gone, and so I'm going to handle the jail and bail arraignments for this afternoon. We have two defendants, I believe the public defender and possibly the prosecutor, going to join us at 2 o'clock. And it's not raining here, but it's cool and gray, and summer is eventually coming. At a meeting at lunch, back to work now. Good afternoon, Raymond from Colon. As I mentioned, tomorrow morning is the first Friday of the month pre-trials, and then a landlord-tenant motion. We have actually a trial scheduled tomorrow afternoon, a civil trial over money damages over the sale of some automobiles between family members. And one of the lawyers withdrew on behalf of the defendants, and I'm not sure the defendants are going to show up tomorrow, but the entire afternoon of May 30th is blocked out for a civil trial. Paddle to the sea. There is a Groundhog Day component to this, but every day is different. All the people are different. And we have to remember that. It's not Groundhog Day to them. It's a new and scary experience for people to come to court. Try to keep that in mind. This is 23 years and 5 months in this job, 23 years in the previous job. And essentially every day is a little different than the day before, even if some of the people are the same, or their kids or their grandkids. All right, I'm gonna shut off the live chat. Thank you for saying good afternoon. We'll try to take care of these two matters efficiently. Here's the jail, and here's our public defender. Good afternoon, Mr. Stickley.
Hi, Judge.
We have two cases. We have actually 3 cases, but 2 defendants. Timothy Wayne Pelfrey and Shauna Lachelle Adams.
Yeah.
Good afternoon, Ms. Adams.
Yeah.
This is Judge Middleton. You're Shauna Lachelle Adams?
Shante Lachelle Adams.
Shanta, I'm sorry. I know that. I'm sorry, I misstated it. You got arrested last night, and the prosecutor has charged you with 2 counts of resisting obstructing a police officer. It's alleged that yesterday, May 28th, in the village of Centerville and possibly also at Three Rivers Hospital, you did resist, assault, or obstruct Officer Kevin Penn of the Sheriff's Department, Officer Zach Radke of the Sheriff's Department as a second habitual offender. You had a previous resisting and obstructing charge a few years ago, 2021, that was reduced to an attempted resisting and obstructing, but it can still be used to make this a habitual offense. So essentially it makes these punishable by up to 3 years imprisonment. According to the affidavit and the bond information sheet, you were quite agitated. You'd been saying things that scared your friends and family, and they called the police, and it all went downhill from there. So are you still living on West Burr Oak Street?
Yeah.
Who else lives there?
Just me and my daughter.
Where's your daughter now?
With my neighbor that just moved into his apartment.
Your Honor, can I have a moment to speak on this, please?
Yes, Mr. Stickley, the public defender, would like to meet with you briefly to discuss some of these matters. So I'm going to put you in what's called a breakout room, and you could talk privately with Mr. Stickley. I have to remind myself that the protocol for these bail arraignments is different than just a regular arraignment. All right, we're back. I left the record running. And yes. Sorry. But nice to see you. All right. One of the things I need to do, Miss Adams, is I need to appoint an attorney for you and set this for pre-exam conference. So I'm going to appoint an attorney because it is a felony. I don't have jurisdiction even to take your plea. I'm going to set a pre-exam conference for June 10th. I'm going to be busy that day. I said that earlier. That's at 8:30 in the morning. And the prelim, if needed, will be June 17th at 1 o'clock. The other function I have at this proceeding is to set your bond. Mr. Stickley, what would you like to offer in that regard?
Yes, Your Honor, Miss Adams is, she is a county resident. I'm familiar with her. And have had very positive and professional interactions with her in the past, heck, even outside of the criminal defense world. So she's a mom. I know she cares deeply about her kids. She is she's definitely going through some things. I think she's recently started maybe receiving some substance abuse guidance in terms of alcohol, which the court's probably not very surprised about. So that being said, we asked that counsel be appointed, and I'm asking that she be released on a PR bond. I understand that an RNO is a very serious charge. So does she. I also understand that some time ago, she had to resolve another charge with an RNO that made her eligible for a habitual second. That being said, I don't think that she's somebody who's not going to show up to court, Your Honor. And I think if bond conditions are placed upon her and maybe she integrates with community corrections, I think that she'll be both safe to the community and she'll definitely show up. She's residing here now, right here in Centerville. So transportation and getting to the court won't be a problem.
Okay. I have a couple of concerns. Back a few years ago, she had a domestic assault where she got into it with a roommate. Matter was reduced to disturbing the peace. And she paid a fine, and she did pay all her fines and costs. 2021, she was charged with resisting and obstructing a police officer. In fact, one of the same officers, Deputy Penn, I did her arraignment at the time and appointed counsel for her. Judge Madison actually did the sentence. She pled to attempted resisting and obstructing. The facts were similar to this. She was uncooperative and assaulted the officer. She was trying to break it. She was drunk, gone to her ex-boyfriend's house and was trying to break in, and the police came and she was uncooperative. The boyfriend didn't want to charge anything. And she pled, her roommate actually called because she was concerned about her drinking and driving, and then that ended up assaulting the police. Last night, somebody called and said they're worried about Shanta. So the police went there and here we are, deja vu all over again, Deputy Penn. And now with him is Deputy Radke. It doesn't say anything in the bond information sheet about whether she was intoxicated, but her booking sheet shows that she was a 156. Adams refused to obey commands by deputies repeatedly. Deputies had to physically restrain her multiple times to make her comply. At one point, Adams screamed and ran at deputies. She was taken to the ground where she did not comply with orders and resisted handcuffing. She was uncompliant walking to the cruiser, and it took 2 deputies to force her to the back seat. Then it continued. At the hospital, Adams continued to try to get past deputies and security. They had to push her back in the room several times. So she was drunk and uncooperative and a danger to the officers and, I suppose, the hospital staff. I am concerned about her daughter, who's just randomly with some neighbors. That's not ideal, but I'm unwilling to do a PR bond. This is the 3rd assaultive offense. It's the 2nd officers who were assaulted. The conduct was in Centerville and continued in Three Rivers. And I'm not going to set it very high, but I am going to set bond at $2,500 cash or surety. There are going to be conditions. Miss Adams, do you have any contact with CMH or any other health provider?
I go to Pivotal.
All right, so you do?
Yeah, I'm supposed to, I just got with a therapist for my mental health. I've only seen her
When
twice.
did you start that?
What?
When did you start that?
Therapy?
Yeah, with your,
about a month ago.
oh, good, that's a good start. Who's your, all right, no drugs and no alcohol. All 3 of these, at least the last 2, involved alcohol. No drugs, no alcohol, test on demand of any police or probation officer. I'm gonna do an 11 p.m. curfew to 6 a.m. I want you out late. No weapons, no assaultive behavior. Cooperate with CMH for Pivotal now. Take all meds as prescribed. Are you taking any medication?
Yeah, I take Xanax and Adderall. And I didn't take my medicine yesterday, so I just.
Well, that's all. Don't go any further. You're fine.
A PR was tempting, but a couple factors. There was at least one previous resisted obstruction that was very similar to this. One of the victims, as I said, is the same officer. This conduct was more than just a push and a shove. It was an ongoing struggle from the get-go in Centerville and continued to the hospital in Three Rivers. I don't think in either of those cases you were placed on a probation. So you haven't failed a probation. You did pay all your fines and costs. But this is, like I said, almost a carbon copy of the 2021 case. So at some point, there's a consequence. And we'll see. I think we're going to need some involvement from your mental health provider. But your hearing date is June 10th, 2025. I expect you'll be able to post this bond. But if you don't, the employer will come out and see you at the jail. I say the reasons why I'm reluctant to do a PR bond. And I'll see you on June 10th. Ms. Adams, you're good to go. If you don't bond out, your attorney will come see you at the jail. If you do bond out, you need to call your attorney, make an appointment to discuss this with them.
Wait, so I can leave today?
Yeah, you're free to go from this room, but you're not free to go from the jail until you post your bond. Does she work someplace around here, or did she? Keith?
She's done a couple of things, but yeah.
Like you, I believe I've seen her outside of court.
I've talked to her in Colon. She was a Colonite. I think she graduated Colon High School.
Okay.
I think I've seen her at a couple of events.
I thought maybe she was a server at a local, one of the restaurants.
I might have.
Because I've seen her other than just here in court.
We had the hardest time typing, or this is totally random, the hardest time typing a word today. Schedulers. How in the heck do you spell? I'm looking up. How do I spell schedulers? That's a weird word. Schedule, ERS, that's it. Okay. Schedule. And then I think I got Matei here.
English. Well, the good news is they unmuted the microphone. Good afternoon, Mr. Pelfrey. This is Judge Middleton. I'm here at the court. With me also is Mr. Keith Stickley, the Chief Public Defender. I've got to arraign you on these two cases and set a bond. First case is from last August 26th. It's alleged that on that day, August 26th of 2024, you possessed drug paraphernalia. You were set for arraignment way back in September of last year, didn't show up, and a warrant has been out for your arrest since that time. You got arrested yesterday. So in the old misdemeanor, the paraphernalia charge, I'll show a plea of not guilty. I'm going to set a pretrial for June 10th. That's not Sturgis Day, but Mr. Reader, Mr. Jordan, June 10th at 8:30. The bond in that case is $200 cash or surety. In the felony case, we'll talk about that one now. You got arrested yesterday. No, this happened in March. I don't know why they didn't arrest you on the earlier warrant then. Back in March, you got stopped by the police and they found a small amount of methamphetamine and some needles in your possession. And they apparently didn't arrest you. They sent it to the crime lab. So let's talk about that. It's alleged that on March 28th in the city of Sturgis, you did possess methamphetamine as a second or subsequent offense as a fourth habitual offender, essentially making that up to a life offense. The allegation is that you had about a half a gram of methamphetamine.
No, sir. Hang on, sir. Don't make any statements before we talk about mine.
And some syringes. They sent it to the lab and that came back as positive methamphetamine. So it's not a terrible set of facts. How'd you get arrested last night?
I was riding my bike and they just see me on the bike and took me in.
All right. Are you staying behind Dunham's?
I'm staying everywhere. I was actually trying to go to rehab, but I don't know. I mean, I was wondering maybe if I get a PR bond or if I like, because there's no way I'm gonna be able to pay any of these things, or if I could wait here and like with your permission, be able to go to rehab and they can come pick me up here.
Well, that's something we can explore, Mr. Pelfrey. You've been struggling for some time here. You can just see it in your countenance. If you could quit methamphetamine, but but right now you're just like a walking wounded. This is your second drug charge and your fourth felony charge with habitual. I can't just snap my fingers and find a rehab. There may be one. We'll see if we can plug into services at Pivotal or somewhere. We don't have as good of a jail connection as we had when Lisa Iantelli was there, but there is somebody there whose job it is. But anyway, I'm going to show a plea of not guilty. Set pre-exam for June 10th at 8:30. Preliminary examination for June 17th, 25, 1 o'clock. And we'll appoint an attorney. I don't know why they didn't arrest you. You failed to appear on your paraphernalia charge. So there's been a warrant out for your arrest since that time, at least since, well, the warrant, it's possible the warrant wasn't out yet when the paraphernalia charge from
the paraphernalia charge is old, Your Honor. It's almost a year old.
Yes, well, that warrant should have been in existence when he got stopped in March. He should have been arrested on the old warrant in March, but he was not. He was released and then they sent the stuff to the lab. I'm going to set the bond at $5,000 cash or surety. Mr. Pelfrey, you're not doing well. You're homeless. You're charged with potentially up to life offense. This occurred in March. In my opinion, you're still using methamphetamine now in May. You're in poor health. You need a little clean time. There's a public safety.
Is there any way you could retest that? Because I don't think it was even methamphetamine.
Well, we'll get to that, sir.
We'll get an attorney to help you with this. Anyway, no drugs, no alcohol, no assaultive behavior, no firearms. I'm not going to give you a curfew because if you get out, you haven't got anywhere to go. And you've been homeless for a year or a couple of years. We need better. By the time I see you on June 10th, I expect doing better than you are now. And at any rate, if you do post the bond, you need to call your lawyer and make an appointment. I don't think you will. In fact, I set the bond as I did because I think you need to stay in custody for a little bit to be in a position to work on your own defense. Anyway, bond is $5,000 cash or surety. No assaultive behavior, no firearms, no drugs and alcohol, which is like telling you don't breathe. But as a condition of that, you take a test upon demand. I'm not going to order testing because you can't afford it and you can't get to the day reporting center. But hopefully when I see you on June 10th, you'll be clear-headed and we can decide what to do with this. All right, Mr. Pelfrey. So I set your whole paraphernalia case for a pretrial on June 10th at 8:30 with the city of Sturgis. And then the felony case will be on the same morning. So good luck, sir. Maybe you can get some sleep here to come back. All right, you're good to go. All right, not very promising, but the other thing, most of the rehab doesn't work. It's so disheartening. Wish we could send them to a treatment place and they'd come out and they'd be treated. But methamphetamine doesn't work that way. All right, Mr. Stickley, thanks for your help. I'll see you soon. I don't think I have anything with you tomorrow.
You're not doing anything else tomorrow?
Probably, yes.
Okay.
I guess I'm it because Judge P's gone and the magistrate's gone. So Yeah, I guess I'll see if we have some. Shayna usually tries to get a couple people arrested every night just so we have something to work on.
Absolutely.
It's just easy. I'll probably run down there in a second. I gotta chat with you about something.
All right, thank you. All right, we'll finish our day. This will bring me something else. Stop the live stream.